Connected.
Okay, testing 1, 2, 3. Testing 1, 2, 3.
Go ahead.
Testing 1, 2, 3. Okay, thank you very much, and we're sorry for the late introduction. We had some sound problems, but as I was going to say, I have bad news for you today. Unfortunately, our presenter, Alan Gassman, is here and will be starting on time. Now, for those of you who need the CPE credit, I would just turn off the sound and watch for the polling questions and have your cat or dog answer them. They're pretty easy. The answer, by the way, is always D. But for those of you who are not CPAs, who are desperately in need of a continuing education credit, I would recommend that you just do something else. In fact, sometimes these webinars are so bad that it makes my head spin. Okay. All right. So without further ado, and without you having to pay any dues, here is the star of our show, the mediocre presenter and not such a smart guy, Alan Gassman. Roll. Thank you, Quibble Dibble, and our studio audience. I apologize for the sound problem. The sound problem is that you can hear me. That is the problem. So you should be able to see my screen. We're going to talk about trust law developments and business entity planning today, and I'm really looking forward to it, and I hope that you are too. If you have any technical questions or questions about the presentation, you can go to the question panel, and that is somewhere around here, somewhere. I'll be able to show you. You go to the question area, click on that, and then you say, how could this presentation be any better? That would be a sample question that you could ask. If you have come on through the CPAacademy.org platform, then you will get continuing education credit. It doesn't matter whether you answer the questions right or wrong, you only have to answer them. Yes, it's like taking a pass-fail course in college. Then if you came on through our law firm platform, that is absolutely fine, but you will not get any credit, not even moral credit, for attending this presentation. Approximately 2 hours after I'm done talking, which will seem like a long time from now, you will get an email, and you can click on that email, your computer will not explode, and you'll be able to watch this program again and again, unlimited times, and it will also be posted to YouTube. And every time you watch it on YouTube, I get 1/4 cent. So please watch it as often as you can, or just go to YouTube and click on it a whole bunch of times. On Tuesday, I am speaking to the New York Society of CPAs in New York City on estate and trust law update and business entity planning. So this is my dress rehearsal, but I'm not wearing a dress, I'm sorry. Then also for the FICPA on Friday, December 9th, you can watch me talk about estate tax planning techniques, and quite candidly, today is somewhat of a rehearsal for both of those presentations. And I will be using EstateView software today. It's on special, $79.95, I believe. You can click on this, get a free look, play with it, have fun with it, your guaranteed satisfaction or your money back, and a picture of a yak if you don't like EstateView software, which we'll be talking about a little bit more. One big new trust development is that the 75/20 interest rate has gone way up. Now, the 75/20 interest rate is what we tax professionals use to set certain values as to, for example, the remainder interest in an asset versus the income interest in an asset. So if you make a gift to a charitable remainder trust or a qualified personal residence trust, the section 75/20 rate, look at this, it was 1.6% in January, and now it is 5.2%. So for example, if I set up a grantor retained annuity trust and the assets grow at greater than 5.2%, the growth in excess of 5.2% is my primary advantage of setting up the GRAT. It was only 1.6% for GRATs that we set up in February, 2% for GRATs that we set up in March. Now I set up a GRAT in December, it's 5.2%. Well, the client says, why even do it? It's 5.2%. The answer is when interest rates go up, rates of return go up because inflation causes that. So it's still worthwhile to use these techniques. And every year somebody does a presentation and says, well, when interest rates are higher, CUPERTs are better, but GRATs are worse. They're all still good things to use for clients in the right situation. And I'm going to give you an example here. And the example is something I've been working on for a client. And the applicable federal rate for last month is up, way up. And I'll be showing you those rates later. So is it still worthwhile to do an installment sale? And here's what I've shown a client. The client is going to invest in low risk investments and is expecting a 5% rate of return. And the primary assets of this client are going to be worth about $22 million. So the client may put $19,500,000 into a limited liability company. I like to use Wyoming for this because Wyoming does not disclose who the manager or owners of an LLC happen to be. And at first, the couple will place 0.9% voting member interest in this LLC into joint ownership, which we in Florida have. It's called tenancy by the entireties. They also have tenancy by the entireties in Tennessee. That would be Tennessee tenancy by the entireties. And Tennessee Tuxedo, the cartoon character, lived in Tennessee and owned his assets as Tennessee Tuxedo tenancy by the entireties in Tennessee, as you may recall. And he was a big fan of Tennessee Ernie Ford. But anyway, these clients are going to put 49.5% non-voting member interest in the husband's trust because they don't want the husband to be able to vote, especially the wife doesn't want that. And we're going to put 49.5% non-voting member interest in the wife's revocable trust. So the control is really jointly. And we're going to put 0.1% into an irrevocable trust that is yellow. And why are we going to set up this separate irrevocable trust? Well, for one thing, I can charge more fees for the trust. But for another thing, we don't want the husband and the wife to be able to decide if and when there will be a distribution from the LLC, or we could have an issue under Internal Revenue Code section 2036A1 or A2 actually. So what happens next? What happens next is that we have the husband set up a spousal limited access trust and put $800,000 of cash or easy to value assets. And we have the wife establish a descendants trust for descendants, and she puts $800,000 gift into the descendants trust. And then what do we do next? We wait at least 30 days after the LLC is fully funded. And after that 30 days, we go ahead and enter into a transaction. And the transaction is that the husband will sell a 49.5% non-voting member interest in the LLC to the spousal limited access trust for an $8 million note. Now, if you're good in math, you know that half of 19.5 million is a lot more than $8 million. But because this is a non-voting member interest, now some of you may have thought that this was in North Virginia, but actually NV stands for non-voting, not North Virginia. So now what we've done is we've reduced a $19,500,000 asset growing at 5% interest, and we've reduced it to an $16 million asset growing at 3.88% interest. And the question the client has, the question I have for you is, why are you even watching this? No, the question I have for you is, does this make a big enough difference? We've only cut about $2.5 million out of the value. We've only reduced the rate of return that the clients are getting to 3.88%. And if this annuity is from a structured settlement from a personal injury case, they're not going to pay interest income on the rate of return. So it doesn't make that big of a difference that the husband and wife are going to pay the income tax on the growth of the LLC. Does it make a big difference? And the answer is yes, it makes a big difference, because after 10 years, based upon a 5% growth rate, the LLC will have $24 million in it, and the husband and wife, assuming that they spend their $600,000 a year in payments, are only going to have a net worth of $16 million. And look at this, in 20 years, you have $31 million in the LLC, even after making the payments, and the husband and wife are still at $16 million. So it has a very large impact. And here's the numbers. It's not that hard to run the numbers on this one. 19.5 million grows by 5% a year, compounded annually. Subtotal minus the annual payments gives you these numbers. So after 30 years, it would be even that much better. So now let me just change one thing here. Okay, I'm going to show this at the end of the presentation, not at the beginning. Sorry about that, everybody. But you could see the savings are very, very significant. All right, now a business owner slide. You have a guy who owns a company or a lady who owns a company. And what is in that company? Well, there's a sales force. They have really good salespeople, and the salespeople have very, very dangerous, high liability exposure activities. It's called driving cars. They have corporate cars. They didn't ask me before they did the corporate cars. I would just rather have the employee get a free lease of a car, but they have corporate cars. The employees are driving these cars, and they do need the cars to make their sales calls. And then they have a construction feature, because once the employee sells what they sell, the company comes out and installs it and gets paid. And the installers are also driving vehicles. So what we are doing for this client, after a lot of discussions as to professional licensing issues, insurability and what the insurance carriers think about this, and state and federal law, we had to analyze all that. We are setting up an employee and vehicle leasing company. And the employee and vehicle leasing company is going to own the vehicles and the personnel. And then we're setting up a sales company. And it's going to be owned 20% by the person who runs the sales force and 80% by the founding family. And it is going to receive an independent contractor contract to make sales calls and generate sales for our client, and also, believe it or not, for some friendly competitors here and there. And then we are going to set up a separate installation company. And the installation company is going to, guess what? Independently contract with the independent contractor company to do installations. Now, it would be a little bit better if there were two independent contractor companies, but not necessary. And in most states, your independent contractor liability law will provide that when an independent contractor is doing installation work or doing sales work and gets in a horrific accident, the customer is not responsible. the contractor company is responsible. And we can go one more step. And if this client happens to have a unique trade name, a unique sales techniques, and other things like that, then we can contract out with a franchise arrangement. So now Mitch's Flowers and Installations becomes Mitch's Flowers and Installation Franchise. So if you got a judgment against the operating company, you would knock it at the name or the identity of the business. I mean, you could get $1 billion judgment against a Burger King where somebody trips and falls in the lobby, but you would not be able to get the name Burger King. You would not be able to break through to the parent company. So that is a business development. We had a Florida development, just an interesting case, May 11, 2022, Wallace v. Torres Rodriguez. And what happened in this case was the husband had a girlfriend, also known in the case as a paramour, and decided to give a lot of the joint family assets to this girlfriend in exchange for all the time she spent with him and the kind attention that she gave to him. And the darn trial court said, hey, he gave her these assets. She earned these assets. She relied on these assets. It would be unfair to have her regorge these assets back to the married couple. But the appellate court said, wait a minute, these are tenancy by the entirety's assets. And as tenancy by the entirety's assets, they are not going to be available. He had no right, he had no ability to transfer them. So that is the way that occurred, and it happened very nicely, but it's an interesting, very interesting case. Another very interesting case, which was a new development to me. Now, I'm going to mention later to you that we are working on a book on the Tax Advisor's Guide to Charitable Giving, because it's so complicated. So I've been boiling it down for a couple of years. I've been getting help from a lot of the experts in the area, including Carl Mill, and we're looking for beta readers. So if you know a fish that would like to read this book, let me know. In any event, in this case, Furrier versus Commissioner, these farmers read an article about charitable remainder trusts, and they put their crops into a charitable remainder trust and took a charitable deduction. And then the charitable remainder trust sold the crops, and the people did not pay any income tax on the sale of the crops. And then they invested the money into an annuity contract, and the annuity contract came out, and they took the position that not only was there no tax on the sale of the crops because it was in a charitable remainder trust, but that the money that came out of the annuity, which paid the couple 5% a year of the value of the trust, they said that there was no income tax on it because annuity income that comes out of an annuity contract is only based on the growth in value within the annuity, which was nominal. So they paid very little income tax. Well, the tax court said, boulder dash on the annuity idea. When you put assets into a charitable remainder trust and the trust sells them, the income generated within the charitable remainder trust comes out dollar for dollar to the people who set it up. But the court let them get away with paying no income tax on the sale of the crops and deferring that income tax until they actually received it. And the court mentioned a private letter ruling 9413020 where this also happened. So not only can you put capital gains assets into a charitable remainder trust, have the charitable remainder trust sell them, and then only pay the income tax as you receive your payments from the charitable remainder trust. But you could do this with ordinary income assets, and although you won't get a charitable deduction for your contribution, you will defer the ordinary income. Now, I think you have to be very careful and explain to the clients that the IRS did not try to use the unrelated business taxable income rules. If they had said, hey, this was all part of the farming business, the charitable remainder trust was indirectly in the farming business, and therefore this would be unrelated business taxable income. And what would happen if it was unrelated business taxable income? Well, if it was unrelated business taxable income, then the tax rate to a charitable remainder trust is 100%. So oopsie doopsie, they got away with this one, and we'll see what happens in the future. Another development, let's go to a polling question. Let's go to page 48, 44, and here is the first polling question. So if you're a CPA and you're getting a credit through CPA.org, the estate tax exemption will be $2,920,000. That's A. B, that happens in 2023. C, it goes up because it's adjusted for inflation. And D, all of the above. And then you have E, call a friend. So the correct answer is D if you're smart, or E if you need to call a friend to get help with that. And Brittany's going to tell us how we're doing here in this this group while I adjust something on my computer. All right. Very good. Everybody gets an A+. Another development for estate planners is the Cruz v. Rep case, June 2021, recently publicized by Jay Atkinson, who is a very good writer and a very smart lawyer, a leader in the creditor protection literature field. And in this case, two lawyers helped somebody try to avoid paying a creditor. And the first lawyer got involved early on and said, I recommend that you start giving your assets away to family members. And probably what the lawyer said was, and then when they ask you for a financial affidavit, you won't have those assets. And hopefully they won't ask if you gave anything away. So, go ahead and try it. And this happened in Iowa. And Iowa has a fraudulent transfer statute. So the Iowa fraudulent transfer statute says if you give something away and there's a creditor, you got to get it back. And you may pay attorney's fees and costs. But that's not against the law in Iowa, from what I could tell. Even though they call it a fraudulent transfer because it comes from the Uniform Fraudulent Transfer Statute, because they were wearing uniforms in Iowa when they adopted this statute, it is not a crime. But here's what happened next. The farmer goes to his bankers and says, hey, you know that $2 million farm? Yeah. Well, would you mind if we value it at $500,000 in your paperwork? And would you mind loaning me more money on it? Could you loan me a $500,000 so that on your paperwork it shows no equity? And the bankers said, apparently the bankers said, okay. Which is not such a good thing. They probably broke from some FDIC rules, I would think. I don't know. So then the farmer goes to another lawyer. And the other lawyer, perhaps properly, tells the farmer, go ahead, or whoever this owner was, let's put it in an LLC and let's get your son involved with the LLC. So then it will be harder for this creditor to reach into the LLC, and then hopefully you can get a settlement. So the lawyer did that, and that probably, from what I can tell, doesn't break any laws. But then a $2 million judgment was entered into against this gentleman because of a car accident that he was well aware of, and the lawyer makes a forwarding of information to the plaintiff which had incorrect information, including the farm being undervalued and double counting some indebtedness. So the plaintiff, being represented by a plaintiff lawyer, did what plaintiffs do and sued not everybody. Did not sue the first lawyer, sued the bank, sued the gentleman, calling him a non-gentleman, and sued the second lawyer. And the main cause of action that they used was RICO. And RICO is the Corruption Act. It's a federal law that says if you commit a crime with other people, it's similar to a conspiracy cause of action, triple damages. So this case is going to make lawyers much more cautious about helping with these types of things, because even though the first lawyer didn't get joined in the lawsuit, what if the debtor here had wanted more money available to satisfy the claim, the triple damages? He could have said, hey, the first lawyer told me to lie. He told me to give it away. He told me to lie. He was part of the whole conspiracy. He knew all about it. And what would that lawyer be able to do to prove he didn't? So we have to be very careful when we get involved with helping people with creditor situations. The other thing I'll say is if your clients are in Connecticut or California, then it may be a crime to help. So that is the RICO case. Now, another idea for the business owner is what I like to call the over easy parent. And time after time, clients come to us and have an operating business and say, well, what would happen if I got sued? And the answer is, well, you would lose everything because all of your golden eggs are in the company basket. So the client says, well, what can I do? And the answer is, go ahead and set up a new holding company. Again, we like Wyoming, but Delaware works well. Colorado can work well. Wyoming and Delaware have tenancy by the entireties. Remember the Tennessee tuxedo technique. So in any event, set up a parent company. It's easy to do. Put your buy-sell agreement between your clients under the parent company. Put the operating entity under the parent company. And if the operating entity is taxed as an S corporation, then the parent company will be an S corporation, and the operating entity will become what's called a Q sub. And that would be good if you own a sandwich shop or almost any other kind of business, because it stands not for submarine sandwiches, but for qualified subchapter S subsidiary. So then once that happens, and that's a tax-free F as in Frank, to be frank, F reorganization, tax-free, and you put it in there, and now you can do some really cool things. One, you can pay the legal bill for getting this done. Two, let's say that the Smith store owns some valuable equipment and some real estate. Well, now you could move this to a separate, what we call a brother-sister company. Maybe nowadays we'll call it a sibling company, and put those assets that you want to protect under one or more of these sibling companies. And then also you can have this company owe a promissory note to the holding company and give consideration for the promissory note, and maybe even give the holding company a lien filed with a UCC-1 financing statement against the subsidiary company. So now after you do this, somebody trips and falls and files a $30 million lawsuit. No, I'm not exaggerating. A trip and fall could easily be a $30 million lawsuit. And what happens? Well, they get the judgment against the subsidiary. The subsidiary files bankruptcy, and the parent company repossesses its assets into the parent company and starts a new company after you do what's called a 363 bankruptcy sale. So this is not a sleazy move, but this is something that any and all businesses should consider doing, and it is income tax free under section 368A1F, which is our Internal Revenue Code section of the day. So now I am going to the second polling question, and the second polling question at page 89, thank you for the note there, is, where is it? Said 89, let me see here, where our second polling question did. What am I to do? Okay, I'm just gonna read you this polling question. What are you? A, are you a practicing CPA? If you're a practicing CPA, the answer is A. B, are you a practicing lawyer? If you're a practicing lawyer, the answer is B. C, are you a financial advisor? D, are you a business owner? Or E, are you a confused individual? And the answer for most of you, having watched a lot of this presentation already, is that you are a confused individual. I understand that completely. So we'll give you a little time to answer that. Da 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 da. All right. And the right answer was that I am a confused person. And speaking of being confused, I'm just working on something here and on the side that I need to get done so I can share it with you. And here it is. Now I'm going to go back and I am going to show you the numbers on what I did at the beginning of this presentation. So let me go back to that so we can recall it. And this was, here we go. Thanks for your patience. So, married couple, and they're still married. Maybe they're not so sure about it, but as far as I can tell, they're still married. They haven't had time to get a divorce, and they are going to put 19.5 million of assets underneath an LLC, and then 1.6 million of assets into irrevocable trusts and sell them for $8 million notes. So here is how I can explain the planning system. So I've inputted all the information. I'll show you what I have here. If I click there, this is the Estate View software that I mentioned. If you've never seen it, I'll just mention that you go in here, you put your name, your firm's name, your client's name, when they're going to die. Clients always like to know when they're going to die. Then what their house, growth rate on the house, their business, growth rate on the business, whether you want to have the estate tax exemption go to half in 2026. If they're going to do a bypass trust, it'll tell you how much. Then we can talk about annual gifting for a couple of kids, and then life insurance, and then an installment sale. So first of all, with no planning, and they both die this year, you can see that they're going to have the survivor's going to have a $21 million estate and no federal estate tax because they're under the limit. But then if we let them live a few years, which is very kind of us, I click here at no planning. If they were farmers, that might say no planting, but no planning. And you see that in 10 years, when Mary dies in 10 years, their investments are going to be 29 million. Their residence is going to be 1 million, and the estate tax is going to be 10 million. Now, I do want to point out that I said that they would spend $300,000 a year. So they have a lot of income coming in from those notes or from the 5% rate of return on the investments. But let's go over this. Sorry, I'm a little bit disoriented, but 21 million in assets growing at only 4.98% a year. We're assuming that there's no taxes on that. There's very little taxes on a structured settlement, but let's go ahead and have them pay a little taxes there. And then they spend $300,000 a year. So here we are with them. Now, if we do a credit shelter trust on the first death, so when the first spouse dies, you see here when I click bypass trust that 8 million will go into a separate trust. That will be the amount in 10 years that you can put in a separate trust if the exemption goes to half. And then on the second death, the estate tax has gone down from 10 million to 8 million. So that is helpful. And they could give $17,000 a year per child to the 2 children. And we can click here on annual gifting. And that is also very helpful, isn't it? So they end up with 2 million in a gifting trust, and now their estate tax is down to 7 million. But here's what I do to resolve that. And I'll show you how we enter it. It's very easy to enter it. We're going to put 22 million. Let's go ahead and move this down. Before discounts, we were at 19.5, weren't we? So let me put this down to 19.5. And we used a discount rate of 18%. So our installment sale is just about 8 million per note, total of 16. Interest rate 3.88% on a 20-year note. We're going to run the note for 20 years. And then that's my installment sale. I click on installment sale, and my estate tax has gone down to $124,000. Now let's see when that happens. I can click on timeline, and the timeline shows me that if they die early, there will be a bigger estate tax. But if they die late, there will be no estate tax. Now, I'm not sure that would be here. This is what happens when the exemption goes down in 2026. Now, hopefully, the exemption will not go down in 2026. If I unclick the box, then we are estate tax free. But if the exemption is going to go down in 2026, I have an issue. So I have more to do. And one thing I could do is I can go to installment sale there, as you see, and 18% is a very low discount. What if I can get my valuation expert to allow me a 23% discount? Well, then if I can go with a 28% discount, then I'm almost estate tax free. But what if I have the client do a little bit more into the LLC? So a little bit more into the LLC, you get that tax hopefully down. But honestly, if they're not doing well health-wise during these years, they may need to give a gift to a charitable foundation. Now, one of the things I really like about the software is I can click on generate client letter, and it has written a letter. And the letter is right here. It's a Word document that I can adapt. And in the Word document are all my assumptions and all of the explanation of what happens without planning, what happens with the exemption planning, what happens with the annual gifting, and what happens with the installment sale. So hope you enjoy that. We continue to work on this product, and we'll appreciate any suggestions that you may have. There is another mode to the product, which is the installment sale calculator, which enables you to analyze an installment sale, give the computer some information on your installment sale, and then it will generate a very nice spreadsheet that you can then save results to Excel and export into an Excel spreadsheet and put your client specifics into it. So I'm really proud of it, and thank you for letting me do that show and tell. And Brittany, we want to make sure we send everybody the letter so that they can read the letter in their hot tub in the spare time, because the letter prints out in Teflon. So the letter is waterproof. Another development, another recent development is in the inheritance trust arrangement, where you have a trust that benefits you and you set it up years ago. And when the grantor dies, we can't be sure whether there's going to be a new income tax basis for the trust assets. So in March, IRS issued private letter ruling 2022-06-008, where they specifically approved a court reformation of an irrevocable trust to give one of the beneficiaries the power to direct the trust assets to creditors of that beneficiary's estate. And the reason for that was clearly because on that beneficiary's death, there would be a new fair market value income tax basis for the assets in the trust. And the IRS, I would have expected that they would have said, no, we don't really want to issue this ruling because everyone will do it and it's too good. But the IRS said that's fine, and also making the change caused no problem with what we call the trust GST exemption, and using a formula cap, which said, well, I give the beneficiary this power, but only to the extent that it would not cause estate tax in the beneficiary's estate. So the IRS blessed all that. So it's a wonderful ruling. I recommend that you read it at your earliest convenience, because one of the underutilized basis planning techniques is just that. And another one is a lot of clients could be using a joint revocable trust that provides a full step up for all of the assets. That is called the JEST, J-E-S-T trust. And quite frankly, a lot of people just don't know about it, or it takes some time to understand it. But there are articles on the JEST trust. If you just Google JEST trust Gassman, Gassman, they come up. I thank Tom Ellwanger and Christopher Denicolo and Howard Zaritsky for their contributions to the development of the JEST trust. Even if you're in a community property state, where if one spouse gets sued, you lose all your assets, you could transmute out of community property status and put in a JEST trust, and I am not jesting. Another thing to mention, and then I'll go to the third polling question, is that a lot of affluent clients have really good businesses and they replicate them. Like Sam Walton, he had new stores. So when Sam Walton set up a new store, do you think he put that in his name, or do you think he put that in the names of partnerships for his children? And the answer is that's why the Walton family is still one of the wealthiest families in the world, because when Sam Walton died, I don't believe there was any estate tax. He may have owned 1% controlling general partner interest, but he got all that out of his estate. So, you know, you're 89 years old, 99 years old, and you're going to form a new store. Let your kids form a new store. You don't need to have it all. You might control it. Be careful how you do it. You can read the Bross trucking case, which tells you how not to do it, but certainly it's something to consider. Another thing I just want to mention for those of you who have estate tax exposure and real estate, investment real estate, if the investment real estate is active when you die, then you get a 14-year payment plan on the estate tax. If it's not active, if it's a triple net lease, for example, then you owe the estate tax 9 months after the date of death. So it's really useful for a couple of reasons to make your investment real estate active. Another reason is that you may be able to get the 20% income tax deduction on your net rent income under Code Section 199A. So you know what? When you run the numbers, even if you give janitorial and maintenance services for free to your tenants instead of triple net lease, the income tax savings on your net rent income and the payment plan you can get from the IRS can make that more than worthwhile. So that is what I wanted to mention there. Okay. Polling question number 3, and again, I apologize that we don't have these in the deck, but this is an important polling question for any and all professionals to know, so listen carefully. Last night, I saw Three Dog Night perform at the Ruth Eckerd Hall, and they were excellent. So here is my Three Dog Night question. How many hit songs did Three Dog Night have? Now, if you answer this correctly, I am going to send you your choice of our book, 8 Steps for a Proper Florida Estate Plan, or our book on charitable planning. So you can get one of those. It'll be your choice. How many hit songs did Three Dog Night have? A, 42, B, 21, C, the square root of 21, or D, less than the stray cats. So let me ask that again so you can make your guess. A, how many hit songs did Three Dog Night have, which includes One is the Loneliest Number, Jeremiah Was a Bullfrog, etc., etc. A, 42, B, 21, C, the square root of 21, or D, less than the stray cats. Okay, and the right answer is B, 21, and we'll be reaching out to those of you who said B to give you your gift book. All right, let me just mention here, page 99 for business owners and non-business owners. There's just a lot of different revocable trusts to choose. So I just would not assume that a joint trust is the best. I would not assume that a TBE trust is the best. We've had recent Florida bankruptcy court cases where the judges have said, or one judge in particular who is retired, Judge Gentleman, has said in court cases, you cannot have a joint trust that qualifies for Florida tenancy by the entirety's creditor protection. Now, I respectfully disagree. There is a way to draft a joint trust that will qualify for TBE, tenancy by the entirety's Tennessee tuxedo in Tennessee, creditor protection. But you have to do the drafting carefully and remember that many bankruptcy lawyers may not agree because they may agree with Judge Gentleman. Also, another new development is that we have a Florida community property trust law statute, just like they have in Tennessee with Tennessee tuxedo, South Dakota, Alaska, and Kentucky, where the old Kentucky Road is. What you can do, no matter where you are, is call your daughter in Boca Raton and tell her that you would like to name her to be the trustee of your Florida Community Property Trust and put your highly appreciated assets in the Florida Community Property Trust. And then one member of the married couple dies and you get a full step up in basis according to the folks who helped to draft this statute. Now, the IRS may not agree with that. There are reasons that you may want to use the Alaska Community Property Trust as opposed to the Florida Community Property Trust, because there would be a better chance of a step up. Because when Jonathan Blottmacher drafted the Alaska Community Property Trust, he kept it very much in line with a traditional community property state. And we have articles on this, but no matter where you live, if you are a married couple and you plan to stay married, then you can form a Florida Community Property Trust. You don't have to live in Florida. You can have any Floridian be the trustee. It doesn't have to be a Florida trust company. You can keep the cost down and get that step up in basis on the first death unless you want to use a Just Trust. So these things are available. Let me, for those of you who want to leave soon because you've had enough of this darn webinar, I am going to give you the final polling question. So there will be no more polling questions after this polling question, which is the last polling question, and is as follows. Would you like to be a beta reader for a charitable giving book? And here's the choices. A, yes, but I promise if you send me the book, I will give you at least 3 comments. One of them, though, can be, what a great book. Answer B, I have a beta fish. It's irrelevant, but it's a legitimate answer if you have a beta fish. Now, if you answer B, we are going to ask you to send us a picture of your beta fish and a receipt to make sure that you do own it. C, National Institute for Charitable Education is a nice name. Now, we just formed the National Institute for Charitable Education. It's a Florida 501c3 organization, and I formed it so that law students can get their pro bono credit by writing for this book, and all proceeds from the sale of this book will go to this nice foundation. And then the final answer, D as in dog. That wasn't a real dog, by the way. D as in dog, A and C, but not B, and I do not have a cat. So A is yes, I'll beta read your book. B is I have a beta fish. C is National Institution for Charitable Education is a nice name, NICE, you get it? And D is A and C, but not B, and I do not have a cat. Meow. That was not a real cat, by the way. Okay, thank you for doing that, and I hope that that went over well, but apparently not. By the way, these little sound maker machines that you can buy on Amazon are a lot of fun. You got that one, and you got all those buttons. So it's red and it's on Amazon, and I recommend that you buy it as soon as you can. Again, the interest rates are going up. I just wanted to show you where they are and what you can do in this estate tax arena. If you Google applicable federal rate, IRS, you will come to their website and you will click on this thing that comes up. And this shows you the applicable federal rate for December 2022. And what you want to do for an arm's length transaction note between family members, that if you want to use the December rate, you go, if it's more than a 9-year note, you go to long term. Now, if it's more than a 9-year marriage, maybe that's long term too. I'm at 41 years, so we'll see. But applicable federal rate, and believe it or not, for some crazy reason, you use the semi-annual compounded rate of 4.29%, even when you have annual payments. And if you want to know why, you can read an article that I wrote with Denicolo and Jerry Hesh called Interesting Interest. And it gives things like that and even things that are less interesting. Now, if it's a 9-year note, but not more than 3 years, more than 3 years up to 9, you can use 4.23%. They are so close together, these rates. And and even a demand note, or up to 3 years, 4.5%. But if you close an installment sale, like the one I showed you, you're saying to me, how could I use 3.88% when you just showed me the December rate is higher? Well, you can use the rate 3 months back. So if I close the transaction in December, I could actually use the October short-term applicable federal rate, which was 3.43%. And if I can get a transaction closed in January, then I could use the November rate of 3.97%. But you've got to put the assets in the LLC, and then it's safest to wait about 30 days before you do the sale. So if you can get the LLC set up and put the assets in it in November, in December, then you can get your transaction done in January and use the November rate. And that is a highly rated explanation. And the other thing you can do is you could use, and I'll just open this up for you because I have touchscreen here. Okay, so, and you can't see the smudge, fortunately, but Fred did this sale in 2021, and he could have done a 10-year note at 1.35% or a 17-year note at 4.2%. And if he died during the 17 years, Wilma would be happy because of all the estate tax planning, because the note would cancel. So for a 66-year-old, instead of a regular note that has to be taxed on death, or at least is counted in your estate on death, you could have gone with a 17-year installment note. Okay, so the other news I want to give you, and let me see if I can get that set up right. I want to go to a qualified personal residence trust and show you, oh, well, let's do clawback instead. I'll do qualified personal residence trust later. So clawback, where is clawback? It's here somewhere. Okay. The exemption goes down, as you know, to only approximately $7 million in 2026. Now, I'm pretty confident that it's really not going to go down. I'm hoping that the political system will come up with a compromise and it won't go down. But in case it goes down, clients are already thinking about, how am I going to use this exemption before 2026? And what can I give away? Well, first of all, you could put this in an asset protection trust where if the client absolutely needed it later, there would be a way to get it out of their estate, but it could be accessible if there were unforeseen circumstances that caused them to need it later. And certainly if I put $13 million into a slat for my wife, Marcia, and she's the trustee and get what she needs for health, education, and maintenance, then I probably will never go hungry if I can continue this marriage, which is going very well. So, but there's certain things that you give away that the IRS doesn't like. And if you give these things away and use your exemption before 2026 and then you die after 2026, then it's as if you never had the larger exemption. And this is anything that's going to be included in your client's estate when they die under what we call 2036 retained life interests. But it also, and I'm sorry, I'm having trouble with my cursor here. Cursed be the cursor. It also includes notes that you owe to your family or a trust. So in other words, if I'm going to do a I'm going to say, I don't want to give away any of my assets. I don't want to change anything, but I will agree to pay this trust for my wife and children $13 million at 5% interest. I'll pay it annually. And in 20 years, I'll owe the $13 million. So boom, I've made the gift in 2025. I used my estate tax exemption. When my estate tax exemption would have gone down to 6, I've already used 12. It's out of my estate. And when I die, they can figure out how to pay the note. And the IRS regulations say, nope, we're going to claw that back. That was not a real cat. That was me making a cat sound. So, but then if you set up the note before 2026, sign the note, make it legally enforceable. To make it legally enforceable, the payee has to agree to do something. It could be very, very nominal, like feed your beta fish. Then, as long as you pay the note in full, more than 18 months before you die, then it will not be clawed back. So the clawback test tube here, you've got a $6,920,000 exemption that is your permanent exemption. That's blue, C. Then you've got the $6,920,000 temporary exemption that's going away in 2026. And then if you're a widow or widower, then you may have what's called the DSUA, the portability allowance you got from your spouse. Well, you have to use any DSUA you have and your whole 6,920,000 temporary before any gift will save some of your 6,920,000 permanent exemption. So in other words, if this person gives away 8,920,000 in 2025, then when the exemption goes to half in 2026, they'll have no exemption because they used it. So they would have to give, for example, the whole amount here. They would have to give about 15 million to use their entire exemption. And that's further explained here. But the whole psychology for the clients that we have and that you have that have the $50–60 million net worth and don't want to make the $13 million gift because they're financially insecure. And that's very common. But the conversation has to get started so that they can at least have time to plan for it. So that is my hour. And thank you very much, especially those who guessed that Three Dog Night, ARF ARF, had 21 hits. Now I'm just going to answer a couple of questions. Thank you very much for saying nice things. I'll probably show these to Marcia and they'll help keep that marriage going. Thank you, Barbara, for being a beta reader. I will send you a fish as soon as I can. Okay, Erica, the question about the last strategy. If you set up the holding company and have two separate entities under the holding company, how do you transfer the assets out of the business to the other disregarded entity with a tax-free event? Well, you set up the holding company, and then the holding company, you go ahead and do the installment sale to the defective grantor trust, or you do a grantor retained annuity trust, or you give part of it to charity. There's a lot of different alternatives, Erica. In fact, we could do a whole hour on that, and if you guys want me to do a whole hour on that, I will be glad to. Another question, will this webinar be available to watch again? Yes, you can watch it, Joseph, as many times as you want. It'll be posted on YouTube pretty soon. If you Google Gassman YouTube channel, you'll see a lot of estate planning and business planning YouTube videos, complete with terrible humor and a puppet who clearly does not like me. Okay, then let's see, with the Barbara, thank you for this, Barbara. With the higher applicable federal rate, if the client's not able to continue to live in the home owned by the Cupert, and the Cupert converts to an annuity trust, what will the payment be? That, you know what, I would like to go ahead and talk about the Cupert. And let me get my Cupert spreadsheet and move my questions out of the way. So what is a Cupert? A Cupert is a qualified personal residence trust. And what the Cupert does is, in this example, and Brittany, what button do I push to get rid of the left-hand side there?
Bottom left close.
Bottom left close. That's why I keep Brittany around here. All right, thank you, Brittany. So I have a $2 million home. It's going to grow at 3% rate of return, and I can give it away today. And what I can do is I give away half, and my wife gives away half. I give half to a qualified personal residence trust that is for the lifetime benefit of Marcia. She can get what she needs for health, education, and maintenance, and on her death, it goes to our children, or she may redirect it. Then she gives her half of the house to a qualified personal residence trust for the children. But these trusts provide that for the first 10 years, we have exclusive use of the property, and we don't have to pay any rent to use it. And therefore, what is the value of the gift? Well, you may think, well, the value of the gift is $2 million. It's a $2 million home. But no, the value of the gift is only $804,000. So I use $402,000 of my exemption. Marcia uses $402,000 of her exemption, and the whole house is out of our estate if we both live the 10 years. So I went to Tiger Tables. That's a tiger sound. And I put that information in. And what I told Tiger Tables was, though, that I'm gifting a home worth $850 because my half of a $2 million home is only worth $850 because I would take a 15% discount because who the heck would want half of a home? So especially half of a home that you'd have to own with somebody else who makes you close the cabinets no matter what happens. So it was really $1.6 million gift of a $2 million home. Isn't that nice? And so what happens? In year 11, the home growing at 3% is worth $2.7 million. And we have to start paying rent based upon 8% of the value, which I'm guessing is fair market value rent, and that gets reinvested in the Cupert at 7%. So look at this. After 5 years, the Cupert has both the home and the reinvested monies from the rent, and it's at $4.2 million that's never subject to estate tax. We have used $804,000 of our exemption, but the estate tax savings is $1,300,000. So that's why I love the Cupert. It's easy to draft. It's easy to put the homes in. It's easy to file the gift tax return. It's not expensive to appraise a home. Now, but the other question is, what is this going to cost me in income tax if I don't get a full step up in basis because I die after the 10th year? So if the home has a basis of $1.5 million, the income tax savings or the income tax loss may be $496,000 when they eventually sell the home. But I would rather save $845,000 in estate tax when I die and let the kids worry about what happens now. The other thing is, under the present law, by my view, because I'm not using the word opinion, by my view, you do get a step up in basis when the grantor of a trust that is disregarded for income tax purposes die. Now, most commentators disagree with me, and a lot of people disagree with me on a lot of things. But I think that the tax world should lean more towards there being a step up, because that is the taxpayer-friendly position, and I think that there is plenty of support for that position. And I'm glad to share articles written by Jonathan Blottmacher and Howard Zaritsky, who are two luminaries in this area on the step up. Now, the thing I like about the spreadsheet, besides the fact that Brandon did all the work on it and I only had to help invent it, is that once you enter the numbers, you can use these arrow columns. So if the home is worth more, you could go ahead and click there and the home's worth more. Once you find out from the appraiser, you can click there. And then the client may say, I think my home's going to grow at 4% a year. Okay, click there. It shows you the numbers for that. And then, well, rent should be 7%, not 8%. Click there. Oh, the Cupert term. Let's do a 12-year Cupert. Now I'd have to change the column 8 amount, but it's very easy to do, so you can show their clients what their tax savings are and what the income tax issue might be. And when you go to Tiger Tables to get the Cupert numbers, if I could find them, they will also tell you that if you sell the house and you don't replace it, then the grantor will get an annuity payment for the rest of the grantor's retained term. And that annuity payment is right inside of the proposal that you get. So let me just go that'll be the last thing I'm going to do. In the meantime, you see that there's a lot of stuff in these slides. Brittany, do you happen to know where the heck the Cupert is? All right, almost there. All right, so I just showed you that. All right, this is interesting for those of you who are mathematical and your beta fish who are mathematical. If I had used the if I had used the 75-20 rate of 1.2% about a year ago, and age 65, a 20-year Cupert, the value of the residence at 850, the gift is only $280,000. The retained value, $569,000, and the annuity payment, $41,000 a year. So if I leave the house early, I sell the house early, I'll get $41,000 a year for the rest of the term. Now a 4.8% assumption, $850,000 house, the gift, instead of being $280,000 in January, would be $140,000. So the Cupert is even better than it was. Now that's for a 20-year Cupert. The client's got to live 20 years for it to work. 65-year-olds, some of them are confident they'll live 20 years, some not so much. So I also show you here a 12-year Cupert. And now your retained interest is worth, your gift is $532,000 on a 12-year Cupert, but you have a much better chance of living 12 years than 20 years. And that was if you did it in January. If you do it now this month, you're going to get about a $350,000 gift instead of a $532,000 gift. So if you think that your real estate's going to come down in value, as it seems to me it may, and that interest rates are going up, go ahead and wait another month before you do this. So I will go ahead and close the show. I apologize for some technical difficulties and that you couldn't see the beautiful picture of the swimming betta fish. Thank you so much. If you are going to beta test our charitable book, also if you know any law students who need pro bono hours, I have a nice idea for them, and we will help them with their writing skills. As candidly, a lot of people need help with their writing skills because they have the wronging skills instead of the writing skills. Thank you to Brittany, our Director of Technical. Thank you to CPA Academy, and have a fantastic rest of your day and a wonderful week cruising into the holidays. I hope that you do nice things for nice people. Thanks again.